Welcome to another exciting episode of Unraveling Intellectual Property with Michael Stein. Today, I am privileged to have Sharat Sasidharan, and hopefully, Sharat, you will correct me if I'm wrong, who is a partner and director at the esteemed law firm of Khurana and Khurana in New Delhi, I believe. Sharat, welcome.
Thank you, Mike. Thank you so much for having me here.
So why don't you tell us a little bit about yourself?
Okay, so I'm basically an engineer. My technology background is electronics and communication, and I started early 2000s as a patent engineer and got trained in US EP India patent drafting prosecution. That was fascinating, especially in India because it is a new field. And so over the years, I have worked very closely with corporates, law firms in US, EP, Asia, and handled huge portfolios with regard to drafting, prosecution, licensing, search, even litigation. Most of
I'm
my
sorry,
work, although
was that
yeah,
mostly domestic Indian or international clients?
mostly international
Okay,
clients,
right.
and I would be trained by the IP councils and house councils, and then I would manage their portfolios globally.
And now you are in the United States for a little bit of time, for a few weeks or something?
Yeah, so start yes. Starting this year, I plan to spend more time in the US, connecting with law firms and corporates for possible collaborations.
All right. And the home office of Khurana and Khurana is in New Delhi. They have other offices too.
Yes, so we are headquartered in a city very close to New Delhi called Greater Noida, but New Delhi is also an office, and we have about 13 other offices in India and 12 offices outside India.
Okay. Wow, impressive. Today, we are going to be discussing the Indian patent prosecution process and how it differs from the US. So, why don't you get us started in how the process uh, works, whether you're filing first in India or whether you have a national stage or a PC or a patent Paris Convention application coming into India?
Sure. So India, like any other, I mean, especially like US, is the first to file. So as soon as an application gets filed, the standard 18 months of publication, is intact, and then there is a request for examination within 48 months from the publication. And from that request, we take another 12 to 24 months for the first office action. That's called an examination report, another 6 to 12 months for the hearing or the second office action. So all in all, we're talking about anywhere between 2 to 5 years. That's a standard timeline, but there are a lot of reforms that have happened that can make it expedited process, and we can target something close to 2 years to maybe 2.5 years for a patent in India.
This is from the date of filing, correct?
Absolutely.
So, I mean, because you mentioned something about the request for examination, which in the United States, when we file, we get the automatic request. You're saying that can be done up to 48 months after the publication or after the filing?
Within the 48 months from the filing, but
Okay,
you cannot file that request before publication. So effectively, if you ask me, 30 months from the publication, but 48 months from the filing.
okay, but theoretically,
So, yeah, good question. So if you want to expedite it, the day you file the application, please file a request for early publication. So within 1 month, it gets published. Immediately file a request for examination. So that's the earliest.
what do most clients do? Because in the United States, generally, we want the earliest examination, but most countries, it seems worldwide, they have this request for examination, and a lot of people seem to like to wait.
Yes. So depending on the clients, especially startup companies that would like to exploit the patent pending status for their, rounds of funding and investor meetings, they would want the patent to be pending for as long as
Uh,
possible,
uh,
especially if they think that, the threshold for innovation is low. Uh, on the other hand, pharma clients want the patent to be examined as soon as possible and a favorable decision, even if it's at the cost of narrower scope of claims.
So you file, you do your request for examination, you get an
Yeah,
office action, you
right.
respond,
Mhm.
you either get a notice of allowance or what?
Uh, yeah, so there are two office actions, and there is only one round of prosecution, unlike in the US, where we can keep on requesting for continued examination. That is not the case in India. So the first office action and the response is written. There is no provision for an interview with the examiner. Then it's either a grant or allowance, or the second option is, which 90% of the cases would be the option. They would issue another office action, and this time you have an oral hearing, and you can submit your written response based on the hearing. And that's it. After that, it is either allowed or rejected. Once rejected, you can go for a review petition. That is prima facie if he or she has made an error in examination, and post which you go for appeal.
But you say, did you say 90% of the responses get another office action?
Absolutely, probably more, 95%.
So
So,
you're pretty much
uh,
going through this oral appeal, correct? Is that
yes.
pretty much the standard?
Yes, yeah. Oral hearing. Yes, it is
Okay.
pretty much the standard. Yeah, 90% of the cases we would see a hearing happening, and also the grant rates in India are pretty high. I would say 75% of cases get granted after the hearing. You amend and you kind of comply with the rejections. The hearing is with a controller, and not with an examiner, and controller is like, let's say, a supervisory examiner equivalent in the USPTO.
I mean, that's just one person, right?
Yeah. No, so there are many controllers. That's why,
No,
because
I
if
know.
you
I'm not
have,
saying it's only one, but when you get that oral
yeah,
hearing,
of course. Yeah,
it's
sure.
only in
It's,
front
yeah,
of
per
one.
hearing, yeah,
Okay.
one person from the patent office. Yes.
And my question is, you file the application, what's the standard time to get that first, or from the time, or let's say as soon as it publishes, you file for the request for examination. What's the standard
Mm-hmm.
time after that to get an office action?
Uh, 12 to 24 months
All right, so you're looking
for the
at two
first
and a half,
examination.
2.5 to 3
Yeah,
years. Okay.
yeah.
And then you have how much time to respond?
So we have 6 months from the date of
Uh,
receipt to respond
Right.
without any extension. Yeah,
And then you get an extension beyond the 6 months?
absolutely.
Okay, it seems like there's a somewhat slow-moving process. If you request the expedited examination, how quick, how much quicker does that get you?
6 to 12 months, it would still take about 8 to 12 months to get the office action. And if you are super fast in responding, you don't wait for 6 months, immediately you respond, and then you can get the second office action in another 6 to 12 months. And you kind of, yeah, expedite the process, the whole process like that.
Okay, sounds good. As far as, so I mean, I guess in part of this conversation, we covered some of the differences. And you mentioned there's no right to an examiner interview, and you don't get to do the RCEs and stuff.
Yeah.
Kind of off the top of your head, are there any other distinctions that people considering filing in India would like to know?
Yeah, sure. So, especially for those, inventions that are related to computer algorithms, software patents, there are, a lot of, I would say, there is a stricter examination in India. Software patentability is allowed only if there is some technical effect or technical contribution that is beyond just software per se. Algorithms and business methods are not patentable at all. There is no caveat. It is not patentable at all.
Wow. Okay.
United States, I think, we have, yeah, there's no statutory concern there, but there are a lot of judicial laws that kind
Yeah.
of have come up with tests and, analysis, two-prong test. So India doesn't have that. There is a statutory provision that, excludes softwares from being patented.
So if you're going to write an application or even a US application to be filed in India, you want to consider it not using the word
Absolutely.
business method,
Yes.
but phrase it
Yeah.
in a different way. And so an expert like you would obviously be helpful in using the correct language.
Yeah. Right, right. And we have to always make it technical instead of saying that a method for, a transaction, a financial transaction, we would simply say a method for performing, an exchange of data between two systems. So there is no mention of stock or money and financial purchase, transaction, nothing, but it
Advertising.
might just be the same invention. Yeah, no advertising. And technical effect that I mentioned is very important because you have to show that there is some improvement and not in the way we live or I feel happier. It is more to do with computer improvement like memory usage,
Yeah,
faster
well,
processing,
I mean,
reduced heating. Yeah,
in
yeah.
that way, it's similar to the US because,
It is. It is
yeah,
similar to the US, yeah. But they would, in the sense, I think in US, if I can do something in e-commerce in a better way, that saves my time or saves makes it simpler is not good enough in India. We still need something that is cooling off better, reduce processing, higher, or better indexing of databases, reduce signal interference. So it's more technical improvement than the abstract or human feeling that I'm getting it faster.
and I think the US also, it's very tough if you just say it's speeding up
Yeah.
the process, but it sounds like India is even stricter. Last item before we get to the end of part one, because we're going to have you back for part two. Does India have
Hmm.
like utility model patents
Uh,
and I'll say regular patents, or is there only one type of patent?
there's only one type of patent,
Okay.
and yeah, it's kind of equivalent to utility, but we do not use the word utility. The third challenge, the first two challenges are pretty common and same as in the US, novelty and non-obviousness or inventive step. The third one is industrial application and not utility. It is not enough that I can, use my laser beam to play with a cat. I need to be able to manufacture that at an industrial scale, and people should be able to commercially exploit it. So industrial applicability is important. Therefore, that's the only kind of patent we have, anything that is novel, not obvious, and can be reduced to industrial application and commercially exploited.
All right. Yeah, I do see those in like the national phase applications that come from the PCT. It'll say industrial application, and it is something
Yes.
that we don't have to worry about.
Yep.
All right, let's wrap up
Sure.
this segment or part one of speaking
Okay.
with Sharat Sharita Sharitavan.
Shashidharan. Yeah.
I'm sorry,
Shashidharan. Yeah, no problem.
Shashidharan. And for the audience out there, thank you for tuning in. Until next time, take care.
Thank you, Mike. Thank you, everyone. Bye.